Hi, everybody. Harry here to talk about the continuing impasse. It's now been a month between Speaker of the House Mike Johnson and Adelita Grijalva, the recent winner of a special election to represent Congress for the state of Arizona. And Johnson has continued not to swear her in, notwithstanding that every other special election, he has sworn people in immediately. And it's quite obvious that the reason is they don't want her to be, as she would, the 218th vote to release some of the Epstein files. Now, Johnson has been doing a dance of different kinds of increasingly implausible reasons for this. He has said, well, I just really would like her to have the pomp and circumstance being sworn in when Congress is in session. Congress has been out of session for some 5 weeks since before her election. Grijalva says, no, that's okay. Not a problem. I'm ready to be sworn in. And it's just increasingly clear that he is bobbing and weaving and ducking to prevent it. So yesterday, Grijalva sued. And she sued for a declaratory judgment asking the court in the District of Columbia, that's one of the places she could certainly say that that's where the omission is occurring, for a declaratory judgment basically ordering Johnson to just swear her in, or if Johnson won't do it, to have anyone qualified to swear in an officer to do it, because the Constitution doesn't specify who will do the swearing in. This is actually, the lawsuit is pretty interesting. It's brought basically under the Constitution. Now, it's under a statute that says you can go right under the Constitution, but when she talks about her rights and goes through it, it is very much Article 1, Article 2. Well, I'll tell you exactly what it is. First of all, the lawsuit is by the Attorney General of Arizona, and they are saying, as a matter of standing, on the one hand, Grijalva obviously is being harmed. She has a job to do. They're not letting her do it. They're not letting her start. But also Arizona is being harmed. Arizona has a right to a certain number, I think it's 8 of representatives. And now they have one fewer because he won't swear her in. And so she sued him and the sergeant of arms and the like. Now, it's a little tricky. Johnson is trying to rest on his basic prerogative to swear it or not, but that's as a matter of House practices and House rules. And the lawsuit says, that has to yield to the Constitution. There's no power to keep out mention in the Constitution. On the other hand, there is this important provision in the Constitution that you're going to see, I think, Johnson rely on. It says the House of Representatives shall be the judge of the elections, returns, and qualifications of its own members. And that's a case and a provision that hasn't come up much, but it came up in one important case in the late 60s involving Adam Clayton Powell. And the court basically held that it is justiciable. That is, they can decide whether or not somebody should be sworn in, and you can't add exclusions. So here's what the Constitution says. If you're 25 years old, you've been a citizen 7 years, et cetera, you take the oath. That's it. So you can't, as they tried to do the way the court construed it, just add and say we're not going to let Powell in. He had done some questionable conduct, and they wanted to keep him out. And the court said, no, he's been elected. That's the end of the matter. The Constitution doesn't say what the oath, how the oath should read, who must administer. There are statutes that say this is the language, but and then another that says the procedure for swearing in. And per that process, any member of the House swears in the Speaker when the Speaker's elected, and the Speaker then swears in the members elect. But, and this is the core of the suit, it's nevertheless basically arguing implicitly from the Constitution, you gotta swear them in. You just can't fold your arms as Johnson is doing and say that they won't do it. And there are rules that the House has passed, but that's just not binding on the court, she's arguing. So, on the bare terms of the Constitution, she's got to get the oath, and if he won't give it to her, somebody else has to. That's the basics of the suit, and it's very basic. Notice there's these first principle. There's only one case out there, the Powell case, and it says you can't, add to the qualifications. Of course, Johnson's view, I'm not adding to it. I'm just not getting around to swearing her in, and the court is going to have to basically say, we're not going to be made an ass of here. At some point, you have to be able to. And I think the argument, since she has standing, that basically it's abridging the constitutional scheme, in effect, giving them one fewer representative. I think, that's probably the focus that will happen when this is served up for argument. So she just goes through the facts and the little bit of precedent that's out there. And then the cause of action is, it's not directly under the Constitution, as I say, because there's another statute. You need a statute basically to sue in federal court. But the cause of action is an ultra vires, which is to say Johnson, is acting outside of his authority. And there's a real controversy going on whether or not she should be sworn in. It's, ripe to administer because she's already been, Arizona is waiting to be represented. So that's the basic argument, very sort of bare bones and just driven by not even precisely the Constitution, but by things that follow from the constitutional text. So here's go through that, and there's no dispute as to her election qualifications. Therefore, court, please issue a declaratory judgment saying she's a member when she takes the oath, and a declaratory judgment, most importantly, saying if Johnson doesn't do it, anybody else who can administer oaths under the laws of the U.S. Or in D.C. So we have kind of House rules and against not even exactly the Constitution, but a view of this is crazy. You're really sort of first principles. You can't just simply under the guise of, well, I haven't gotten around to it yet, ignore your duty. You couldn't do it indefinitely. I'm sure that will come up in court. So what's the reasonable time limit, et cetera. So that's going to be an interesting argument because it's sort of based on first principles. The impasse got to give, and pretty soon. And that will have immediate political consequences because she will be the 218th vote to release the Epstein files. And that's really the reason most people think the House isn't even in session, that's the one kind of kryptonite that sticks to Trump so far, and it will reignite the controversy when it happens. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.